500,000 signatures in 24 hours. Could this be enough to force this government out? And what is Yvette Cooper doing, saying that she's going to expand the recording of non-crime hate incidents despite the whole debacle with Alison Pearson? So lots to get into in this video, but first of all, if you do like a brutally open, honest, frank and objective approach to the news, the law and what's going on in the country and around the world, please do consider subscribing to my channel. Help me grow. I'm headed towards 700,000 subscribers, which means I'm well on my goal to 1 million subscribers. So please help me achieve that and I'll be really grateful. So this is quite staggering. 500,000 views in 24 hours, which has surpassed the threshold of 100,000 signatures, which then puts it forward for a debate, potentially. But what impact will that really have? And is it legally binding? Sorry to disappoint some of you, but, well, 500,000 of you by the look of this petition, but it is not legally binding in almost any respect at all, really. Apart from the fact, really, that it's a sort of non-statutory parliamentary process that requires the government to respond to a petition that's got at least 10,000 signatures. That just provides a response. And more than 100,000 signatures will be considered for a debate. Now, there are certain criteria. It must be a sufficiently clear petition, and I suggest that this is pretty clear. It says call for a general election. I would like there to be another general election, and I'll come back to that in a minute. And this page here, again on the petition website, says that almost all petitions that reach 100,000 signatures will be debated. But they may decide not to put a petition forward to debate if the issue has already been debated recently or there's a debate scheduled in the near future, etc. So it's entirely possible that the government may say, well, actually, we've just had an election, so we're not going to bother debating this, so this might all be a complete waste of time. But let's say they do debate it. What happens then? Well, even then, not much may happen. It may be a bit of a debate, a bit of an embarrassing debate in Parliament, depending on how many signatures this eventually gets, if it does end up being debated. And obviously, I think everybody but Labour, and perhaps even some of Labour, I dare say, may be calling for a general election. Now, whilst this is entirely possible, I somewhat doubt that will happen, but it's entirely possible. But since the Dissolution and Calling of Parliament Act of 2022, this act restored the prerogative power to dissolve Parliament, effectively repealing an old bit of law, and now means that the Prime Minister can request the dissolution of Parliament from the monarch, and generally the monarch, the King, will act on that advice. And that, of course, will trigger a general election. This also dispensed with the 5-year requirement, so now timing is at the discretion of government, subject to the Prime Minister's advice. So if there were a debate and it were very fierce and the general feeling was that there should be a debate because there's, let's face it, a lot of disgruntled people around the country who would obviously want another general election based on everything that's happened recently. This is entirely possible, but realistically, probably somewhat doubtful. However, that doesn't stop the petition growing. It's growing as we speak. I'm looking at it every few minutes and it's still growing by the minute, by hundreds and thousands of signatures. So this at the very least illustrates that a lot of people are disillusioned with this government, and even Elon Musk jumping in to say this is interesting, that this petition has broken the record, apparently, for the fastest time to reach 100,000 signatures, which was previously held by Justice for George Floyd. So I will watch this with interest, but don't get too excited. There is nothing legally binding about the petition, nothing legally binding about having the debate in Parliament, and even then nothing legally binding on the government at all. But it would be influential. On an entirely separate note, I'm really excited to share with you that one of my partners is having a massive discount on its products for this year's Black Week. But not only that, they are giving away 3 PS5 consoles to lucky customers. So if you want to be in with a shout to win one of those, check out the details carefully in the description below. It's a company called HOLY who produces energy drinks, hydration drinks and iced teas that are packed with vitamins and antioxidants. They do a huge range of flavours and have just brought out some new flavours, including a really interesting one here called Double Apple and Shisha, a mysterious energy drink flavour called Woodruff Wolf that I'll leave you to discover for yourself, and a very traditional and old favourite flavour, Bubblegum. These are really delicious and enjoyable drinks, and the reason I took them on as a partner is because about 14 months ago, I'm keeping track, I quit drinking alcohol completely, and so throughout the evening I was looking for something else to drink, and water got a bit boring. I didn't want any more fizzy drinks, and so these absolutely fit the bill for me. Of course, as a partner to my channel, I get you a discount off their products, but this week is special because you get an extra £10 off their starter set deluxe, which is 42 servings of their best-selling flavours. And what better way to find out which ones you enjoy more? So not only do you get a £5 discount using the code Barrister5, but you get an additional £10 off this starter set deluxe. Or you can use the code Barrister to get a 10% discount, which might be better for larger or ongoing orders. And for both of those, you'll find convenient links in the description below. So having tried lots of different flavours now, I can assure you there's something for everybody. I would highly recommend you go with the starter set deluxe, try all the best-selling flavours, find the one that you like. Don't forget the discount codes and of course the PS5 giveaway. The details are in the description. So if you're looking for a health kick and an easy way to get extra vitamins and antioxidants, give HOLY a try. You won't regret it. And now back to the government thinks about what you say and think with so-called non-crime hate incidents. And what is Yvette Cooper doing, saying that she's going to expand the recording of these? Has she forgotten what the Court of Appeal said not all that long ago? You may have heard of the case Miller and the College of Policing. Particularly if you've followed the Free Speech Union, I suggest you pop over there and join as a member if you value your freedom of speech. Now, this is the summary to the case. I'm going to jump to the judgment in a minute with one or two very interesting points to pull out. This very much talked about free speech as against the recording of a non-crime hate incident, which sounds a little bit of a contradiction in terms, because if it's a non-crime thing, then surely the police shouldn't be recording it at all. But nonetheless, that's what's happening. Now, the background of this case, this was an appeal. It went to the Court of Appeal. The Hate Crime Operational Guidance document issued by the College of Policing set out the national policy in relation to the monitoring and recording of non-crime hate incidents in respect of 5 monitored strands. Under the guidance, the police must record as non-crime hate incidents complaints, just complaints of incidents that are perceived by the victim or any other person to be motivated by hostility or prejudice against a person who is within one of the monitored strands, irrespective of whether there is any evidence of hostility. Breaking that down for a moment, if anybody perceives, either the victim or any other person, anybody perceives that something is motivated by hostility or prejudice, even where there is no evidence of hostility or prejudice, this will be recorded against that person under the guidance as a non-crime hate incident. So the police recording something, putting on their database, putting on their records, something about you as a hate incident, even though there's no evidence of it, and it's just a perception by either an alleged victim or any other person. This summary goes on. Mr. Miller was someone who became the subject of a non-crime hate incident record following a complaint about comments that he made on Twitter concerning gender recognition. The comments were made in the context of a government consultation on proposed reforms on the Gender Recognition Act that placed greater emphasis on the self-identification by a person of their gender. Before the court, Mr. Miller challenged both his treatment by Humberside Police and the guidance itself. He succeeded against the police, but the challenge to the guidance initially was dismissed. So on appeal, he challenged the lawfulness of the guidance at common law and Article 10, freedom of speech. The Court of Appeal unanimously allowed the appeal on 2 grounds. And the reasons for the judgment are as follows, which is really important, which is why I'm reading this to you. You may not have found it, you may have heard about it, but here it is. Hopefully this is of use to you. If it is, please do subscribe down below. The guidance clearly constitute a real and significant interference with the right to the freedom of expression. The risk of recording in such a case, together with knowledge of that risk and potential disclosure of non-crime hate incidents on enhanced criminal record checks, for example. Just to explain that a little bit, it's really important that if you understand an enhanced criminal record check, which you will need if you go to work with, let's say you want to go work in a school, you want to teach children, work with children, any of those kind of things, they'll do an enhanced criminal record check, and one of these might pop up. one of these non-crime hate incidents, it will flag up that you've got a hate incident against your name, even though it's just a perception by an alleged victim or any other person. So somebody may be watching and think that looked like a hate incident. It's perceived to them to be a hate incident. There's no evidence of it at all, but it's just recorded because it's reported, it's recorded against you, and it will show up on an enhanced criminal record check. This goes on. Had the potential to create a chilling effect in relation to public debate on controversial issue, and as to whether that interference was justified, the guidance pursued the legitimate aims of the prevention of crime and the protection of the rights of others. Furthermore, the measures taken were rationally connected to those aims. However, those aims could be achieved by less intrusive measures, and the overall impact of the measures on the right to the freedom of expression was therefore disproportionate. In particular, although the guidance contained two narrow exceptions to the general rule that complaints must be recorded, the lack of any common sense discretion not to record irrational complaints meant that there was a risk of recording incidents which are essentially non-crime, non-hate incidents. The guidance made no provision for any proportionality exercise in relation to the recording and said nothing about the language to be used in such a record or whether the subject should be notified that an incident has been recorded. Such safeguards, as there were in the guidance, did not sufficiently address these issues. Less intrusive measures could have been used to achieve the legitimate aim of recording incidents of this kind without unacceptably compromising those aims. A revised version of the guide was issued in October 2020, which emphasised the need for proportionate action by the police. However, this did not go far enough to address the chilling effect of the perception-based recording in the circumstances described, and that is why the court unanimously upheld on two grounds. Now, just moving very quickly to the judgment itself, throughout this judgment it talks about the chilling effect on free speech, and notably one or two paragraphs here. The court said, in my view, the principles of law that protect freedom of expression and which underpinned much of what the judge said in support of his conclusions that the police had infringed Mr. Miller's rights were matters that should have led to the same conclusion against the college. Furthermore, these revisions, with the greater emphasis on proportionality, appear to be designed to meet the criticisms made of the police conduct in this case, and it could be said that at the very least they demonstrate that there was scope for less intrusive measures. But in my opinion, they do not go far enough, or not nearly far enough to address the chilling effect of perception-based recording more generally. But then we come back to the Telegraph article reporting that Yvette Cooper is planning to expand the recording of non-crime hate incidents despite this backlash recently with Alison Pearson. It says she's committed to reversing the Tories' decision to downgrade the monitoring events, specifically in relation to anti-Semitism and Islamophobia. They can be logged by police. Now, objectively, a lot of people have criticised the use of the term Islamophobia, and I will give an objective view here, which is that a lot of people may not have any hate whatsoever towards Muslims and Islam generally, but they may have a genuine rational fear of certain extremism, whether that is from Islamists or anywhere else. If that is a rational fear, then it is not a phobia, therefore it is not Islamophobia. And so there's a lot of debate over the use of terms here, and I, for one, would just appreciate people being absolutely straight with what they mean. Some people may be perfectly happy with the Muslim community in general, but at the same time, it is very rational, in my view, to have a genuine fear of extremism. I don't think that's controversial to say. And of course, I would think, and I would certainly hope, that the vast majority of the general public would not be prejudiced, racist, and this would not apply to them. All of this against the backdrop that the Inspectorate of Constabulary in September found that many forces were still failing to correctly apply the guidance. It uncovered evidence that confusion over the rules meant officers were taking a risk-averse approach and summed it up as, if in doubt, record. So they were recording pretty much everything that they thought someone's feelings got hurt. Police have recorded non-crime hate incidents after a person refused to shake hands with the victim, was perceived to be hate-related due to gender identity. They also logged a rough haircut reported by a customer who claimed that the barber was aggressive because they had a discussion about the Ukraine war. On the flip side, on a more positive note, Yvette Cooper has urged police to use common sense when recording these incidents. and has pointed to recommendations by the Inspectorate for improving training and clearer direction for officers. Home Office source, according to the Telegraph, said, "We support the Inspectorate and College of Policing assessment that there needs to be a common sense approach and consistent approach that means trivial, irrational or malicious cases should not be recorded." So, of course, you will have your views on that. If you do leave comments, please do leave them respectfully. This video of mine is not intended to upset anybody nor encourage anybody to be upset with anybody. It is intended to be a sensible, rational discussion about how we as a society should use this common sense approach. And objectively, perhaps we should not be recording these incidents so easily unless there is a real hate behind it. If something was entirely prejudice and entirely motivated by hate, and it was of the nature that we want to stamp out of society, that's entirely another matter. But I hope you found that an interesting overview. Please do like the video. I'll give you time to do that now. Make sure you subscribe to the channel, hit the notification bell, and I'll see you next time.